Speaker, I rise in support of the Children's Guardian and Other Legislation Amendment Bill 2026. As the Deputy Chair of the Committee on Children and Young People, I know how important it is that our laws keep pace with the realities facing children, families, carers, service providers and regulators across New South Wales. The protection of children and young people is not an abstract responsibility, it is one of the most serious obligations we hold in this Parliament. This bill makes practical and important amendments to strengthen child safety settings in this state. It clarifies existing legislation, supports the work of the Office of the Children's Guardian, improves consistency across related acts, and implements changes arising from the statutory review of the Children's Guardian Act 2019. At its heart, this bill is about making sure the systems designed to protect children are clear, workable and effective. It amends the Child Protection Working with Children Act 2012, the Children's Guardian Act 2019 and the Children's Guardian Amendment Act 2025. These are not merely technical changes, they are changes that help ensure child safety, decisions are supported by the right powers, the right information and the right safeguards. One important part of the bill relates to delegation. Earlier this year, the Deputy Children's Guardian was appointed to provide strategic advice and support to the Children's Guardian. However, despite that appointment, there are existing limitations on the functions that can be delegated within the Office of the Children's Guardian. This bill sensibly resolves that issue. It allows the Children's Guardian to delegate functions under the Children's Guardian Act 2019 to an officer of the Children's Guardian with appropriate exceptions. This means the office can operate more effectively and respond to matters in a timely way while maintaining proper accountability and oversight. The bill also strengthens the reportable conduct scheme by bringing within its scope organisations that provide overnight camps as a main function of their service. Many children and young people, overnight camps can be formative, positive and memorable experiences, but those settings must also be safe. Where organisations are principally providing overnight camp services, it is appropriate that they are subject to clear obligations to report and investigate allegations of child-related misconduct. Importantly, the bill does this in a measured way. It focuses on providers for whom overnight camps are a main function, rather than imposing disproportionate administrative burdens on smaller, community-based not-for-profit organisations where that is not the central purpose of their work. This reflects a balanced approach, strengthening child safety where risk and responsibility require it, while ensuring regulation remains practical and proportionate. The bill also deals with substitute residential care. The existing framework is being updated and the commencement of the new definition of substitute residential care will be delayed until 1 October 2027. That delay is not a retreat from reform. It is a common sense step to ensure the sector has time to prepare properly. Substitute residential care can include arrangements such as overnight respite or behaviour support for children. Changes to this definition are likely to bring more services within the relevant legislative obligations, including the reportable conduct scheme and the child safe scheme. It is essential that affected organisations understand their responsibilities and are supported to meet them. A strong child safety framework must be robust, but it will also be capable of being implemented well. This bill also supports the Office of the Children's Guardian in accessing the information it needs to assess whether a person is safe to work with children. That is fundamental. Parents, carers and communities expect that people who work with our children have been properly assessed and that the regulator has the tools it needs to make informed decisions. At the same time, the bill supports procedural fairness, ensuring that those subject to these processes are treated consistently and appropriately. The Office of the Children's Guardian performs vital work across New South Wales. Its role is specialist, complex and essential. It oversees systems that exist to protect our children and our young people in schools, services, organisations and care settings. When we strengthen that office, clarify its powers and ensure the law operates as it was intended, we strengthen protections for children across the state. As legislators, we must ensure that child safety laws are not only well-intentioned, but also effective in practice. This bill is practical, proportionate and necessary. It improves clarity, supports the sector readiness, strengthens oversight and keeps the safety and well-being of our children and young people at the centre of the legislative framework. I want to thank Minister Washington and her team for all the hard work that they have put into this area over the last 3 years. It has been a great body of work and I really do commend them on what they've been able to achieve thus far. And it is for those reasons that I commend the bill to the House.